Hello, everyone. This is Tom Fox back for another episode. And first of all, I'm absolutely thrilled to have another Texas lawyer on a podcast. I rarely get to do this. So, first of all, welcome to Art Gollwitzer. Art, first of all, welcome again. And thank you so much for taking the time to visit with me today.
Oh, thanks for having me.
So, you work at Jackson Walker, and I asked you if you would come on and talk about it on the pod. You graciously agreed to do so. Here we are. Let me draw on your litigation background and how you might counsel companies to either prevent or detect potential litigation areas. And I want to start with the work you've done in the False Claims Act area. Could you describe that work you have done for clients?
Sure. I've both counseled clients on how to avoid such cases and defended clients in the face of both private and government allegations under the violations of the False Claims Act. Specifically, I think most recently I had a several year long investigation by a government agency that was a customer of a client that involved lots of witnesses, lots of documents, pretty much what you'd expect of a serious False Claims Act case. But obviously we try to avoid that, right? We'd rather help clients avoid the expense and the time and the resources that are required to defend one of those.
One of the things that I try to counsel clients on, I'm usually in an advisory role, and I make very clear I do not do investigations, is that if an issue comes up and we feel internally it is at an appropriate level, we need to get outside counsel, specifically investigative outside counsel involved as soon as we can for the investigation. And as opposed to perhaps trying to do it internally in-house and then deciding now it's time to bring in a true expert. And I really want to use the reason I do that is I find professional investigative counsel is generally better than in-house counsel on investigations because that's what you all do. I was wondering if you could talk to us about perhaps some of the issues you've seen when you or one of your colleagues might get a call a little bit later in the day after the initial investigation has been done, and perhaps the regulators are knocking at the door.
That's a great question. I completely agree with you. That sounds self-serving. Yes, of course, hire outside lawyers and spend all the money that requires. But seriously, these cases can be very large, right? Whether it's what's known as a key tom plaintiff that is doing this on its own, looking for a cut out of the supposed improper payments and represented by lawyers who are taking a contingency, or whether it's a government agency, an inspector general. The cases are large, the consequences are large, the money involved is ultimately for some businesses, they might be facing what's called disbarment, where they are no longer allowed to do business with a particular government agency, which could be very destructive to the client's business. So they have to be done right. And that's not to say that the in-house folks or other lawyers can't do it. But those of us who have some background in criminal law and quasi-criminal law, who have done investigations, who've spent time with, in my case, as an assistant U.S. attorney with law enforcement agents, we've spent years interviewing witnesses, asking questions, and sort of dotting all the I's and crossing the T's. So, for example, witnesses and company employees should be advised of their rights, or in this case, really what rights they don't have. It's everyone's familiar with the Miranda warnings on Law and Order, right? But in this case, what we want to tell an interviewee is, look, I represent the company, not you. And what you tell me is not privileged, or the company holds the privilege is a better way to put it. I'm looking out for the company's interests, and there's little steps like that you want to make sure you do right so the employee doesn't think you're their lawyer. Likewise, even within management, it's a really good idea to form a separate committee, an investigative committee that supervises me as outside counsel, that's possibly authorized by the board, given its marching orders, so that there are, no indications of influence or bias. I should explain that better. What happens if a senior officer in the company is potentially involved in the alleged wrongdoing? That person can't be running the investigation. It affects the credibility of the investigation. Forming a committee, giving it specific power to hire outside counsel, and then letting us do our job without the influence of people who are potentially impacted by the investigation makes the whole thing more credible. Why does that matter? Is if you're dealing with a government agency, now this applies more to government investigations than that private plaintiff, but the government agency, the government investigator, even criminal prosecutors, they love and reward self-disclosure, contrition, remedial measures. All that stuff is more credible when you can go to the inspector general or go to the assistant U.S. attorney and say, look, here's what we found, here's what we've done, here's how we're fixing the problem. That's all more believable and has more credibility when you're independent. So really long-winded answer to your question, but it comes down to doing the investigation right and then having credibility when trying to resolve the matter.
I've talked to a lot of expert investigative counsel over the years, and to a man or woman, they always tell me the most important thing investigative counsel brings is their credibility. And it's their credibility to do a truly independent, effective investigation, but equally important is their credibility with regulators. And I don't know if the same question is asked, but 10 years ago, always the first question was, are your documents tied down? And if you didn't give an answer to that question, you started down a potential road of losing credibility with the regulators. Does any of that story resonate with you? And is it still true in 2025?
100%. And again, by tied down, I assume you mean preserve. We've looked into what's relevant. We've preserved what's relevant. We can turn it over to the government if needed. Yes to that, and yes to credibility in general. I think an earlier question earlier in our discussion, I think you may have touched on sort of lessons learned as a prosecutor and what's changed over the years. And one thing that I fall back to, or I think back to, is when I was an assistant U.S. attorney, I felt like there was more civility, more credibility. In other words, your word, your handshake mattered more than in my straight up civil practice fighting over intellectual property disputes. And that may seem counterintuitive because in a criminal case, a pure criminal case, jail time, an individual's liberty may really be at stake. When dealing with a corporation, this may just be significant amounts of money, maybe disbarment from a government program. And so you'd think, wow, the stakes are higher. You'd think people would be more aggressive. And yet it's a small circle. I was an assistant U.S. attorney in New York, where you'd think big city, lots of players. And yet the folks doing these kinds of cases are a pretty small circle. And so your word mattered. And that's where you get your credit. That's where you get to credibility, right? If a defense attorney asked me for a favor or asked for an extension or just explained something to me, he needed me to accept his word, and vice versa. If I promise someone, look, you help us in this way, you do this, let's tie it to FCA cases or any kind of government corruption cases. The Justice Department under multiple presidential administrations has emphasized early disclosure, right? But as a lawyer for the company, I need to really have faith that if we come in and self-disclose a problem, but the government's going to give us credit for that it really is better to come in early than wait. And so the prosecutor or the investigator's credibility matters. And then again, by the same token, as representing that company, when you come in and you lay out the cards and you say, here's what we found, it's been contained to this little area, here's how we're going to fix it, you need them to believe you. And if any of that turns out not to be true, then that damage is really hard to repair. And how does that tie into the documents, as you say? That's where the proof lies, right? If you represent to someone that, hey, the alleged problem is limited to this one department, here's what they were doing wrong, here's how we fixed it. If the documents belie that, then you have a problem. Or, as you may suggest, if the documents don't exist, if they're mysteriously disappeared, then you didn't have them buttoned down right from the beginning, and that's a problem.
Or another reason I've always thought important to bring in investigative outside counsel is around the privilege. Now, I understand a general counsel can have an attorney-client privilege, and those working under a general counsel inside of a corporation can have one. But I also know that oftentimes somebody who works under a GC may have multiple roles in a corporation. They may be giving business advice. They may be counseling executives. They may do investigations. I suppose they could even handle litigation. And so sometimes the hat of work product gets a little fuzzy. But if I
Yes.
bring in someone like yourself who doesn't do a business counseling or other similar work for a corporation, it's much cleaner. So I was wondering if you could say a few words about the privilege that you bring as a true outsider and as investigative counsel, and how that can be at an advantage to a company.
You're right. If you've done this before, I mentioned a moment ago the company that is conducting an internal investigation or that's faced with outside allegations, forming, hiring outside counsel, doing it with very specific instructions, and likely even forming a supervisory committee within the company of disinterested people, right? So as outside counsel, someone needs to hire me. So I need to report to someone, practical things. Someone needs to review our bills. Someone needs to worry about the budget. Someone needs to make sure we're staying on track. And you want that to be people within the company who, again, aren't part of the potential problem that you're investigating. Hopefully they're independent. And by creating that committee and having written authorization from the board of directors as to here's what the committee is going to do, you're going to hire outside counsel, here's the scope of outside counsel's investigation, all that helps define the scope of the work product doctrine. Right? So this ties into the privilege, right? It makes it clear I'm not just providing this hybrid business legal advice that may or may not be privileged. It's essentially a written request. If we think back to the law school elements of the attorney-client privilege, it's confidential requests for legal advice from the client to the attorney are privileged, and therefore the answer is privileged. The work product doctrine applies when there's a reasonable anticipation of litigation. If we spell out in writing that here's a potential problem our company has, here's what we're going to do about it, we're asking Art for advice on this particular area, you've laid out all the elements of those two privileges, and then my work within those parameters should be privileged. Why does that matter? First of all, you want to be able to speak freely with your client, but I also may need to go hire outside experts. Maybe we need an accounting expert. Maybe we started this interview talking about AI. Maybe we need a computer engineer, a programming expert, an AI expert to explain how the system is working, right? Because to tie this back to AI, maybe the False Claims Act allegation is based on the company either using AI in a way that it's certified to the government that it wasn't, or the opposite. Maybe this government program or it's the company's service depends on it using artificial intelligence in a certain way, and the allegation is that it's really not. So maybe we need an expert witness to explain what's happening behind the scenes. If I have clear directions from the company and I turn around and hire an expert within the scope of those directions, then that expert's work is privileged as well. And we get to decide whether we want to waive that privilege as part of resolving the matter down the road.
And I'd like to perhaps ask about any areas in the new Texas series of AI rules, laws, and regulations which you think could perhaps lend itself to a False Claims Act claim or other private party lawsuit.
Good question. I'm going to start by being more general, and I just hinted at it in my last answer. What it looks like we're going to see, I guess I'm reading the tea leaves or predicting the future a bit here, is False Claims Act litigation under sort of these false certification theories, where you've certified to a state or federal agency for False Claims Act federal, but there's state law equivalents. You've certified that you're using or not using AI in a certain way. Right? That was a requirement of the program. It was a requirement for your company to get the contract. And I say this is, I guess I'm predicting this for a reason, that we've seen this in the ESG space, where I think people even refer to it as greenwashing, where they say they're doing something, right? They say let's make up an example, the energy they're using to run the facility that's producing the product that the government contracted for is coming from renewables or whatnot. And it's really, let's say it's really not, or the allegation is that it's not. There's just lots of self-promotion that look how, I have a new laptop on my desk and it has a sticker on it about how much of it was made in a certain way. Those sorts of certifications people have challenged with lawsuits saying I think even the SEC has investigated quarterly required SEC reports, annual reports, quarterly reports, making certain promises and that allegedly weren't true and allegedly were material to investors. So you've seen it in the ESG space. I think you're going to see the same thing in the AI space. It's hard to turn on your TV or stream a program without an advertisement from some company touting how much it uses AI to enhance its products. Is that really true, or is it just marketing? So you're going to see it there. Now within the Texas, so that's separate from the legislation. But if we look at the legislation, there may be some limited areas. The reason I'm hesitating is most of the Texas laws that were just passed are things companies strictly cannot do, or certain requirements that I'm struggling for the moment to tie them to a particular government program. So I'll give you an example. Healthcare providers under Texas law, under one of the new laws, can use AI in diagnostics, so assist in diagnosing patient conditions under certain conditions. So it's expressly allowed, but the healthcare provider needs to inform the patient that it's doing. The healthcare provider still needs to act within the scope of his or her license. So yeah, it may seem obvious, but let's say the healthcare provider is a physician's assistant whose license does not allow him or her to maybe prescribe certain medications or whatnot. You need an MD to do that. Just because you have access to AI doesn't allow you to sort of do things that you weren't licensed to do. So those are very strict requirements. This is what you must do. Things that a lawyer in-house or someone giving compliance advice in the healthcare space may want to talk to their clients about how to make sure, hey, as you introduce AI, these are little things you need to do. And maybe we have a way to record the fact that you've informed every patient of this. But until I'd have to tie that to a government program, and I suppose it must exist, where the government would ask you to certify that in exchange for these government payments, for these Medicare payments or something, you certify that you have followed this Texas law. Okay, now you're in the False Claims Act space if you make a false certification about what you've done.
I would like to turn or maybe circle back to almost where we started. And I believe when you were at AUSA, you worked in the Southern District of New York. And I was wondering if you could say a few words about what it was like to work in the Southern District of New York. And once again, I'll preface this question with everyone outside of the Southern District of New York thinks that's really the top district in the United States, and that the people who work there are not only very talented, but they're very committed and were led by very talented, very committed U.S. attorneys. So I was wondering if you could say a few words about your personal experience in the Southern District of New York.
It's an honor to serve there. It's an honor to serve as an assistant U.S. attorney anywhere. They're great jobs, and there are terrific AUSAs in every district. Being a Midwesterner by birth and now a Texan, I want to overemphasize one district, but you're correct that some extremely high profile cases are brought in that district. It's very competitive if you're seeking to work as an AUSA, it's very competitive to get into that district. You work with some outstanding lawyers, outstanding defense lawyers, outstanding judges, agents. Like I mentioned a moment ago, 20 years later, I treasure the fact that I could probably get more done with a phone call and a handshake in that world than I can in the typical large civil case, because if a defense lawyer called up and said, I really need something, and they had a good reason, I just took their word for it. Again, it was trust but verify, as President Reagan said, right? If someone spent their credibility unwisely, if they blew their credibility, you remembered, but therefore people didn't. I really enjoyed that aspect of not having a confirming letter or email for every little thing. But that's, again, I believe that's true probably in every district. We saw a variety of cases. I was only in the office there for 3 years, but even in those 3 years, you see everything from street crimes to simple fraud cases to political corruption. And that breadth of experience helps make me a better lawyer. It helps you see a lot of different kinds of cases. You work with so many different people, right? Again, in my civil practice, we spend almost all of our time with specific decision makers at our client, probably house counsel, opposing counsel, the court, and expert witnesses. As a prosecutor, you're dealing with victims, law enforcement agents, witnesses that come from all sorts of backgrounds, a significant breadth, a variety of people that I think just hopefully make you a better communicator and a better lawyer, and open your mind to how there's lots of different ways to think about a problem. Which, maybe to wrap that part of this up, whatever kind of law you're doing, I think of our job as problem solving or problem preventing. And the more ways you can think about a problem, the more readily you might spot it in advance or come up with a creative solution.
And then I want to end by asking this question, because I never got to do this. What's it like to stand up in a U.S. federal court and announce that you're representing the people of the United States?
I'm smiling because it's wonderful, right? It's a privilege. It's really, I could envision myself serving again in some capacity someday. It's an honor. If you, like me, believe we live in a country that's special, we have rights and liberties that are worth cherishing and fighting over, regardless of politics, to stand up and say I represent the United States of America it gives me chills. In fact, a quick story is there's different styles I've noticed over the years in different districts. Some lawyers will get up and say, and I don't want to criticize anyone's style, it's just a personal choice, but my thinking about this, I never said I represented the government, which is a common phrase. You hear it a fair amount. Because I felt like I didn't represent the government. I represented the United States of America, and that means the people. That means our nation, not a particular government. So that meant a lot to me to stand up and say, Your Honor, Arthur Gollwitzer, on behalf of the United States. That was a privilege.
Arthur, I wanted to thank you again. Thanks for your perseverance throughout this process. I hope we can continue this conversation.
I appreciate your time. Thank you. It's fun.